In this video, we will discuss a real estate contract, what it is, the different types of contracts, the elements of a contract, and a review of some of the keywords and phrases to help you understand the fundamentals of real estate contracts. Welcome, my friends. This segment is about contracts, what you need to know about real estate contracts before working in real estate. First off, you'll need to successfully complete the real estate licensing examination, of course, which covers both state and national materials. Now, contracts are likely to be one of the most heavily tested topics that you're going to find on the real estate exam, so it's important to have a really good understanding of this particular content. So a real estate contract, what is it? A real estate contract is a document between two or more parties involved in a real estate purchase and sales, exchange, or transfer. It is a legally binding document and it outlines the terms of the agreement as well as what each party's duties and responsibilities are. For a real estate contract to be valid, it must be in writing. Any real estate transaction requires a contract. They are intended to safeguard both parties and to serve as a foundation for legal action that can be taken if the contract terms are simply not met. All right, in this next section, let's talk about the 5 elements to a contract. So to establish legality, a real estate contract must include these elements. Number 1, the offer. When a party makes an offer in a sale, this is called the offer to purchase, and presents it to another party. Now, number 2 is the acceptance of that offer. The offer can be accepted by the other party by signing it and thereby making it official. It is crucial to obtain the signatures of both parties that are involved in the contract. Now, number 3, consideration, money or services in exchange for something else. Number 4, legal capacity. Both parties involved are legally considered to be competent, of sound mind and body, and of a minimum age. Typically, it's 18 in most jurisdictions, rendering them capable of entering in to this contract. And number 5, the legality of purpose. The contract's purpose must be legal in nature. Period. All right, the next topic is the types of contracts used in our business. Number 1, the offer to purchase. This is the first step in a sales agreement between the buyer and seller. The next contract is a purchase and sales agreement, one of the most common legally binding real estate contracts. The P&S, as we call it, is an agreement between two parties, the real estate seller and the buyer, that specifies the terms and the details in the sales and much more details than the offer to purchase. The lease agreement is next. And this contract binds the property owner, also known as the landlord, and the tenant. As a result, the landlord agrees that the tenant can occupy the property at a set monthly rate so long as they continue to abide by the terms of the lease. The next contract is the buyer's agency agreement. This is a contract between the real estate agent and the broker or the buyer, outlining the terms of the relationship, including the agent's professional duties and the buyer's ultimate responsibility to compensate the agent. And the final one here is the listing agreement. This agreement enables a broker to act on behalf of a property owner as listing agent to find other buyers for the property and the seller's terms. And they include the desired sales price and things of that nature. A final one that many times comes up is the option contract. Now, this is a unique agreement between the seller and the buyer. It considers a particular piece of real estate and grants the buyer the sole right to purchase that property. Once this option is activated, the property seller will be unable to sell the property to anyone else until the agreed upon time frame expires. In an option contract, the buyer has the option, but not the obligation, to purchase the subject property, making this a unilateral contract because only one party has to perform. Let's talk about some key terms to remember. Number 1, the assignment. This is an agreement in which the assignor signs over their contract rights to a third party. The one who receives the assignment steps into the assigner's shoes and fulfills the contract terms. You will often see contracts in wholesale real estate transactions when a wholesaler comes to purchase agreement with the seller and then transfers that right to a third party. The next term is novation. This happens when a new contract of equal value replaces the existing one. Novations allow an original party in a contract to transfer all of the benefits and burdens to a new party not included in the original agreement. In effect, the novation renders the original contract null and void and replaces that one with a new one. Rescission. This may occur when a contract is declared null and void or no longer is recognized as legally binding. This happens when there are errors in the contract. Fraud or other applicable circumstances may lead to rescissions as well, and a rescission can be mutually or unilaterally, depends on the circumstances. The next one is specific performance, a classic. This is a contract law remedy most commonly used in real estate litigations and disputes. The court issues an order to one party to perform a particular action in accordance with the terms of the contract. You may see this in a real estate transaction if a seller changes their mind shortly before closing and the buyer takes legal action to force them to sell at the agreed terms. Earnest money, a deposit paid to a seller and held by a third party, which demonstrates a buyer's good faith in making real estate purchase transactions. These funds allow the buyer to make a partial deposit to secure a home while giving them more time to obtain financing, complete the title search, property appraisals, and inspections before closing when the remainder of the purchase price is due. Power of attorney. This legal document grants the attorney agent or other named person in this legal document the right to access and manage the principal's property if the latter cannot do so themselves. Discharge. This is the termination of a contract. A mortgage discharge is a document that formally states that a mortgage debt has been paid off. Breach of contract. This happens when the parties fail to perform what they've agreed to do, in whole or in part. Mutual assent, the agreement of both parties in a contract. In real estate contracts, a signed, accepted offer demonstrates mutual assent of the buyer and the seller. Unilateral versus bilateral. A bilateral contract is an agreement reached by at least two individuals or entities where both parties promise to perform. A unilateral contracts or agreements where only one of the parties in a contract has the duty to perform, while the other party may have the option but no obligation to perform. The difference between a bilateral and a unilateral contract is pretty important. The most noticeable distinction between bilateral and unilateral contracts is the number of parties promising to act. Bilateral agreements require at least two parties that promise to perform a specific task, but unilateral agreements only require the action from one party. All right, let's define what is valid, what is void, and voidable. All right, so void contracts are not legally binding and cannot be enforced. In most instances, a void contract lacks one or more of the essential elements covered earlier. Because it is not an enforceable contract, neither party is required to terminate it. Valid contracts, in contrast, are legally binding and enforceable in court. They contain all of the necessary components and are enforceable, which means by a court. Voidable contracts are valid contracts and enforceable contracts with the flaw that could render them void, including a mistake, failure to disclose a material fact, intentional misrepresentation, or fraud. A voidable contract does not have to be terminated. Both parties can agree to continue with this agreement or agree to ratify or fix the voidable contract. Contracts are a major topic that will be covered on your real estate licensing exam. If you still have questions, be sure to check out my videos and overview on real estate contracts and leave a comment if you'd further like clarification on one of these types. Good luck getting licensed, and I look to see you in an upcoming training.